Let's bring into the conversation Dr. Conor Casey, who is a senior lecturer in public law and legal theory at the School of Law at the University of Surrey and is also a senior fellow at the Policy Exchange think tank. Thank you very much for joining us, Conor. First things first, who's right here, the politicians or the judiciary?
Well, first of all, thanks for having me. I would say in this instance, it's not even close. I think in this instance, the parliamentarians and ministers are on very solid constitutional footing. I think this is regrettably a very ill-advised and misconceived intervention from the Lady Chief Justice.
She says that sort of part of the rationale it's been spoken about is because of judges being sort of targeted and facing a huge amount of abuse. Do you have any sympathy with that argument that she's put forwards?
It's a general matter of principle, yes, of course. That's utterly unacceptable. But note that the exchange in the House of Commons was nothing in that vein whatsoever. There was no ad hominem attack. There was no questioning of the judge's motive or their background. This was squarely engagement with the substance of a legal decision, which in many ways is incumbent upon government and Parliament to do if they're to discharge their policy-making and law-making functions properly. So I absolutely sympathise with that. It's a problem. If it becomes a problem, that would be a serious trouble. But I just don't see how this exchange in Prime Minister's questions is connected in any way whatsoever.
Do you think this sets a worrying precedent that means politicians might be slightly loath to bring up cases at Prime Minister's questions, cases that have featured on the front pages of newspapers like this? Do you worry that sets a sort of bad example?
I don't think so. It would be immensely regrettable if that was the case. But I take heart from the, as you said, strangely unanimous show of unity between opposition and government on this matter. We've already had firm, respectful pushback and confident pushback from the Prime Minister's office, Leader of the Opposition, saying that we just don't think this engages judicial independence or rule of law concerns whatsoever. This is our function as government and Parliament. We are entitled to debate the merits of these issues. So that kind of confidence gives me hope that this will not lead to a chilling effect.
The distinction, as far as I've sort of seen, based on hearing experts talking about this, is including yourself, is that you've got politicians who are criticising, the judgment that has come out in this particular case, the fact that a sort of family from Gaza was able to come over on a scheme that was meant for Ukrainian refugees, but then also the law or the policy that has allowed that to happen. I mean, should you be able to criticise both or just the latter, just the fact that there is seemingly a bit of a legal loophole, as the politicians might see it?
I would say that in this case, there is a fair critique to be made of the substance of the judgment, that the problem is not actually the policy itself. What happened was that the applicants in this case looking for an entry visa, they didn't meet the criteria under the normal immigration rules, nor they definitely didn't meet the criteria under the Ukraine scheme. So what they were asking for was the minister to exercise a sort of residual backstop discretion they have for exceptional circumstances. And the minister said that we don't think it applies in this circumstance. And we also don't want to set a precedent that could lead to other conflict zones, creating entry schemes through the back door. So that the court said that this was an impermissible exercise of discretion because it didn't give enough respect in the court's mind to the right, Article 8 right to private and family life. That was not a judgment compelled by the legal materials. The first instance court held in the opposite way. So this is an area where there was a measure of legal underdeterminacy, and it was an exercise of judicial discretion that was not mandated by the policy. So I think it is fair to assess and scrutinise the legal reasoning that went behind that decision and whether it's weak and whether its consequences could be impactful and should be revisited.
Thank you very much for your time. Dr. Conor Casey is a senior lecturer in public law and legal theory at the School of Law at the University of Surrey and a senior fellow at the Policy Exchange think tank.